Lender security. Now, we talked about this a little bit already. Typically, there's no property that can be mortgaged. There's not something you can put a charge on. You can't charge common property. So, I've got the answer up here. This is an easy one. So, what can be offered? Anyone know? A general security agreement. How intuitive. Fantastic. A GSA. Okay, a GSA is offered that provides a charge over what? What does a GSA provide a charge over? Everything. It's typically what it does. You read the language of a GSA, and it's all-encompassing. But practically speaking, it doesn't really give you any rights over the common property for the reasons we talked about. So what does it give the lender security over that they care about? Money. The bank accounts. What bank accounts? Operating? What about reserve? Well, what do you mean it's spoken for? Where is it spoken for that you can't? Uh-huh. So you're saying that the Act might not allow them to. Any case law that says that they can't? Is there any case law at all on a defaulting condo loan in Canada that you're aware of? I'm not. And that's what the interesting things about this. We've got case law up the wazoo on mortgage defaults. But this stuff, as far as I know, we still haven't seen a default. Where's Wallace? Jim, have you heard of any yet? Nope. I haven't heard of any yet. So far, it's been a very secure type of borrowing, and I'll talk about some of the reasons why. So when we talk about what that GSA attaches, it attaches, if you look at the wording of it, you should look at it carefully. Does it actually attach the reserve fund? There's an argument in my mind that if it doesn't exempt it out, that they may try to attach it. So whenever I'm acting for a condo corporation, I like to see that in the actual the loan terms, so the term agreement, that exempts it out, or that exempts it out in the GSA. If you don't, potentially they would have the ability to go in and access the reserve fund, subject to the fact that it would likely end up before a justice as to whether they can or not. Okay? So that's what the GSA does. It provides them with access over the operating account and possibly the reserve. Maybe. It shouldn't. My opinion would be it shouldn't. It's a statutory fund. However, ask you this question. So what?
Why would you borrow money if you have money in the reserve fund?
Exactly. So what? You got $2.5 million worth of work. You got an underfunded reserve. You got $50,000 in the bank at any given time, maybe, depending on when you paid your insurance. Who cares? Right? Is this the only security that we're offering these guys? If that was it, there would be no condo borrowing. So what does the lenders, what do the lenders get? Why do they do this? Somebody said blood. That's not it. Assignment of condo fees. All right. You're going down the right track. Assignment of condo fees, but your condo fees have to pay for the insurance and everything else. So what can they do? What's that called? Special assessment, or now a special levy. That's the hammer. That the lender can say to the board, you defaulted. Congratulations on being the #1 test case in Canada, guys. You now, as a board, have to pay us out, and pursuant to the terms of our loan agreement, you now have to special assess the owners. Remember that. You now have to special assess the owners. And what if the board says, upon careful reflection, we've considered your request and we've said no? What then happens? Receivership. The GSA, as well as the loan agreements, are going to talk about the appointment of a receiver. Have we ever had a receiver that's appointed to collect on a condo loan in Alberta? No. Canada? Not that I'm aware of. Can it be done? I would say yes. Any reasons why we think it's entirely possible for them to do it? Well, one, you've got somebody who has a significant financial stake in the condo corporation. Is there any legislative concept that exists already whereby someone else can oust control from the board and take over? What's the term called in the Act? Starts with A, ends with administer. Administrator. Our Act already allows for removal of the board and for placement of an administrator. Now, I haven't seen what this would look like, but I'm guessing, and I think it's a pretty good guess, that what a court would do is they would appoint an administrator with limited purpose. And that limited purpose would be to levy and collect. That administrator, I don't want to touch your snow removal. You board, you guys can stay, but we have this specific power. We can assess and we can collect. Now, here's where it gets interesting. Here's why this is actually a fairly safe loan for lenders. In the event you special assessed or special levied unit owners and unit owners don't pay, what happens to that unit? You can go into foreclosure. And because that repayment of that amount that you had to pay, where does that rank in regards to getting paid out on the sale? Anybody know? After the mortgage? After the taxes? Before the mortgage? First?
But it'd be joint, right? So the ones that are fully paid for, they pay the whole brand.
Here's your answer. It's before the mortgage.
Is it?
It's before the mortgage. So for those of you who've been involved with collections before, either as managers or for boards, who often, when people go into arrears, not all the time, who often pays the condominium fees? The bank. Why do they pay? Because they fall behind in priority. They don't want the condo corporation to exercise their statutorily provided rights of foreclosure under Section 39 of the Condominium Property Act. And that's why if you actually read standard mortgage terms, you know that like 30 pages of 7-point font stuff that you give when you buy a unit, I've actually read them a couple of times. Let me tell you, that is time I will never get back. It's a default of a mortgage. It's a default of the mortgage if you don't pay your taxes, you don't clean, you don't dust. I'm kidding. You actually have to maintain though. But you don't pay your condo fees is one of the defaulting terms on a mortgage. That is why your banks pay. And so interesting when you look at this, and I had a discussion with a bank recently that they were sort of fudging, well, I don't know, there's kind of a lot of risk with this loan. Really? Because if you give the loan and you don't get paid, you actually rank ahead of your own units that you have security in, right? It's a strong type of security. But this is what you're signing up for. Now keep in mind that phrase, special assess the owners. I'm going to be circling back to it. Reasons to borrow. Why do we borrow? Why do people want to borrow? We've already talked about some of them. Minimal reserve fund to address repairs, years and decades of minimal maintenance, significant capital costs, unexpected costs. Here's a good one, litigation. So you're suing the developer for $2 million. If the money comes in by way of settlement or an award for damages, and everyone's already paid it, how do you get that money to flow back to the owners? Can you? We actually had a debate on this in the legal panel. I said, no, you can't do it. There's no basis to dividend back to the owners. One of my colleagues on it says, well, there might be a way to do it. I'm like, good luck. I can tell you this, in one of my clients up in Fort McMurray, they got wiped out in the fire. They had a series of special assessments, significant ones. There were a series of 5 over 2 years. 2 of them were paid. There were 3 still outstanding. The fire happens, wipes it out. They don't need the money for repairs anymore. It's going to be rebuilt brand new. So they canceled the remaining 3 special assessments. However, there was about 15 units that had been bought and sold during that period after the first assessments had been issued. And guess what all of the purchasers had required as a term of their purchase? the vendor has to pay out all the special assessments. All the ones that have been levied, not yet due. All of a sudden they're canceled. Money has to be refunded. Who gets the money? The vendor or the purchaser? Lawsuits arose. So my thoughts personally are, if you think that unit owners are going to get the money coming back easily, if money comes back in from a settlement or a judgment, good luck. Buckle up. It's going to be a mess. So a loan solves this because the loan can get repaid as money comes in. Now, here is the reason why I changed my tune on borrowing. Remember when I said that 15 years ago I said to the client, oh, geez, Louise, this is going to be costly and expensive, just special assess. I changed my tune. And here's the reason why. Somebody can't pay that special assessment. Let's say it's only $5,000. Are there people that you will know that can't come up with $5,000? Yeah. What happens if they can't come up with that $5,000? We already talked about it. You trigger foreclosure remedies by the Condo Corporation, which very likely triggers the bank foreclosing. We've all heard of CMHC financing, National Housing Act financing. Section 44 of the Law of Property Act is the following. If your unit is foreclosed on and it's conventional financing, conventional meaning they put down at least 20%, and there's a foreclosure, then the owners can literally go, here are my keys, I walk. It's conventional financing. The property is what the lender is limited to. However, if that was the case, no lender would ever lend with less than 20% down. Too much risk. And so what you have is you've got CMHC financing or GE financing, and then you have a change to the Law of Property Act, which means that, in essence, in the event that you have a high ratio loan and there's a default and there's a deficiency, meaning that the sale of the property doesn't pay it off, the debt continues. And so if you got some poor family that can't pay that $5,000 special assessment and they're forced into foreclosure, by the time that process goes through with bloody lawyers and then a forced sale, which is typically a little below market, you're financially ruining people. This is why a loan is potentially a very compelling option for people. You're not worried about the impacts on what that decision may have, specifically special assessing upon neighbors. All right, other reasons to borrow. You can amortize costs. More competition. We're seeing rates coming down. Talked about the rest. Reasons not to borrow. Why don't some people like it? Well, there's legal costs. Who likes lawyers, really? Administration costs, administration complexity. And I'm going to talk about an opt-in, opt-out situation. Perceptions of debt is another one. Some people really don't like debt. They're in a minority, but there's those people out there. Higher condo fees. When you repay a condo loan, how is it repaid? Condo fees, the contributions, they will be higher. Okay? Now there's some corporations that I see where they've got, here are my contributions, here's my condo fees, and here's the loan repayment. They do that just to kind of show owners, break out the costs. It's all one bucket. It's contributions. It's condo fees.